Welcome to Divorce Decoded. My name is Isaac Grunenbaum, and I have with me Eliana Baer. Eliana, would you introduce yourself?
Hi, I'm Eliana Baer. I'm delighted to be on the podcast with you. I'm an attorney in Princeton at Fox Rothschild, which is a large national firm, but I specialize in family law in New Jersey, and I have a statewide practice. I do everything from appellate practice to mediation, arbitration. I appear in Baston, I appear in civil court, so really runs the gamut in terms of my specialty and my practice, but mostly family law, mostly divorces and custody and things of that nature.
Well, okay, so we have the whole every approach to settling your divorce case. Let's talk about as a mediator, like the first thing that we learn is mediation, and then we learn how to apply it to whichever field. So I do divorce, so it's how do we apply mediation to divorce? I'm assuming law is similar as well, where you have the law and then the field that you become an expert in. So I'm going to go just mediation in general, right? One of the things that we think about is what are the ways to resolve conflict? So what are the ways to resolve any conflict? And we think about it as either you work it out, you fight it out, or you have someone else decide. So let's bring that over to like divorce would be like working it out together, or mediation. Having someone else decide would be either court or arbitration, Besden. And then you would have, fight it out. You could pick it outside someone's house, have them get fired from their job, alienation, all those things that, I don't think we should be doing, but let's discuss them. Like in these three approaches, like how do you think about it? And you do all of them as well. Like how do you navigate for which one to do?
Right. And a lot of it actually depends on what went on right before they come to me during the marriage, because a lot of times people have really dysfunctional marriages, which lead to really dysfunctional divorces, right? So if you're dealing with somebody who's really level-headed and they're parting ways and they just want a nice amicable divorce, usually that'll go to mediation. And that's how they'll resolve their disputes. Now, high conflict cases can go to mediation, but it's just a little bit more difficult because a lot of times you have somebody who's not acting in good faith or tries to get a tactical advantage by alienated children, which really is abhorrent behavior, but it's an advantage to them because they don't care about the best interests of their children. So they're engaging in all of this poor behavior. And to mediate with somebody like that is definitely more difficult. It's doable, assuming you have the right representation, parameters are in place to control the behavior. But typically, when you have a really toxic, sometimes violent marriage, that's going to be the fight it out cases, as you refer to them. It's going to be like you're getting down and dirty in the mud and you're litigating every aspect of the case. You can't even agree which day of the week it is, let alone, what your children's custody schedule will be. And a lot of times those cases end up where you'll get somebody who's making a disingenuous request, right? So you're getting somebody who makes a request like, I've never parented in my life. Our roles were clear. I've gone out, I've made the money, you've been the parent. And not to be gender stereotypical, but typically it's the woman who stays home, raises the kids, and the man goes out to work. And then suddenly the man comes and he wants 50-50 custody. And it's not a genuine request. It's a request that's designed to harm the children and the wife, mostly the wife, because
You don't mean that it's never a genuine request,
never,
but in
no.
your scenario, it's
in
not.
the scenario where there's a
Okay.
toxic dynamic that already exists, where there's just this high conflict marriage and somebody's using the children as pawns. And 50-50, again, a lot of times a legitimate request. And social science says that it's best to have two healthy parents, to every extent possible, equally involved in the children's lives. The issue becomes when one parent is not engaging in healthy behaviors, including making a disingenuous request or making it out of spite or doing something other than that that's really like a low blow to create the conflict in the divorce. So you're basically getting what you put in. I always say garbage in, garbage out. Like you're getting the divorce that reflects usually what happens during the marriage. However, there are times that people can rise above that and they can try and work that out and say, okay, what happened in our marriage happened. We have to put our heads together and decide what's in the best interests of the children. And that can really work. I'm always a fan of mediation first. I think that settling a divorce is best for parties. It's best for children, most especially, not to drag them into a protracted litigation. And I always tell people, it doesn't matter if somebody has one more day or one less day with the children. What matters is, did you have conflict surrounding them? Did you fight about them tooth and nail? And did you make their life so unbearable and insufferable that they don't want to have anything to do with either of you? Or they're forced to take a side because they're put in the middle, and it's easier for them to take a side than to stand up to one parent. So, those cases are always the toughest, where people don't put their kids first, but the cases that have the best outcomes really are the cases that are mediated and in the children's best interest, where both parties have the same goals.
So you're saying like you would start always with mediation if possible. If you could work it out, there's no reason to escalate. But then there's certain cases which are escalated. And I guess you're pointing out like some people are using, they want to gain, they'll bargain from extremes, right? Where, maybe you only want a certain amount of time, but you'll say that you want 50-50 because then I'll get the one overnight that I wanted versus just having a supper visit.
No, that's actually more legitimate than the alternative. What I'm describing is a situation where somebody's specifically using it to hurt their former spouse.
But you're saying to hurt it, not even as negotiating from extremes.
Correct. Negotiating from extremes is fine.
You're fine with the negotiating from?
I mean, I don't think it's helpful in mediation. What's really helpful is collaboration when you're going through mediation. That's, the gold standard, let's put it. But how many cases are really the gold standard? Not very many in my experience, maybe because I'm at heart a litigator. I have a
selection bias, right?
Right. At heart, I'm a litigator. So, I tend to get the people who are litigation minded, but that's not to say that you can't also be mediation minded. Despite the fact that you're, in this litigation, you could still stop and take a breath and say, okay, how do we resolve this in mediation? And there are opportunities to do that throughout the process, meaning you don't have to commit to one or the other. They're not mutually exclusive. You don't have to pick a track the second you walk into a divorce.
Meaning I would tell people not to escalate, but then if you are already in court, obviously you're not going to just say, okay, let's drop everything out of court so we could go back to mediation. You could put a pause on it, but you're not going to like lose where you're holding in court, right?
Right. You sort of step out for a second with everything pending
because
and just
you're at that point already. But there's no reason, like if someone's just fresh out of a divorce, I would always tell them like the first thing you should say is, hey, I would like to get divorced. Let's do this in a peaceful way if you're amenable to it. If you're not, then okay, that's not my choice, but I'm happy to sit down without any preconditions or anything. Just let's sit down and figure it out. That would be like the go-to advice.
I agree. And I always tell people that. I say, let's start with a letter. If you think they'd be receptive, let's start with a letter and say, I've been retained. I haven't filed anything yet. Let's see if we can go to mediation. Sometimes I'm met with silence. Sometimes I'm met with a yes. Sometimes I'm met with a no. So it'll all depend on what that other party brings to the table. I always say I can only control 50% of the equation. 25% is my client. 25% is me. The other 50% I can't control.
So let me ask you, because if someone's X is being represented by you, future X, and they want to settle it, they want to reel it back a little bit, how should they approach you? What should they say? Like, they want to approach you and say, hey, Eliana, what's that letter, what's that letter supposed to say? How should they go about that?
I think to say, I'd like to negotiate in good faith. Can we schedule a mediation? That's all that's necessary, really. But their words have to match their actions at the end of the day, right? You can't come to me and say, I want to go to mediation, but then cut off the finances and start pressuring somebody into a settlement that's disadvantageous. Or, you could be using religious means to try and get to mediation, to try and extract certain concessions in favor of a more beneficial settlement to that party. So in some sense, you have to be consistent, in which case I'll say, absolutely, this person's acting in good faith. They're saying they want to negotiate in good faith. We should absolutely go to mediation. That is something I would recommend to my client if those two things aligned. The problem always arises when there's a disconnect there.
Right. So I guess it's a little difficult, that's not really my clientele anymore. but when I did work for the Besdin, this is going back a number of years, where you had certain people would be calling in, okay, we have court on this and this date, like it's coming up, and we just want to see maybe we could figure this out. Like, um, in those situations where sometimes you're not getting the best mediation because again, these are not people that were able to live by that or able to leave a marriage and just say, okay, we don't need to break everything on our way out. Um, let's try to do this the best way possible to start this new life. That wasn't really per se the mindset. They might be coming to mediation because it's cheaper, because it's easier than, having the judge rule, than not knowing what's going to happen. But it's not necessarily coming, the way I want my clients now. They're coming because this is what they want. This is, so it's a different client. But so where do you draw the line in, like, okay, well, are they really being genuine? Or, what? Okay, they're only settling because they don't want to be in court. How do you, it's a little difficult because it's not really per se what they wanted. They wanted their, your client, let's just say, to just give in or whatever it was, right?
Right. I'm less interested in the motivations for going to mediation versus what happens when they get there. And are they negotiating in good faith, right? Like, it informs me what their conduct has been, and the surrounding circumstances certainly inform the decision, but it's not the only factor. So I'd look at everything. I'd look at, well, what has happened to date? Are they engaging in good faith? Just generally, are they paying all the expenses? Are they keeping lines of communication open? Even if they're not doing that, I think there's still common ground that could be reached with the right mediator. And you seem to have a more collaborative approach, which is, again,
that's my clientele.
Gold
really,
standard.
Yeah.
Right. That's the gold standard. You want a collaborative approach to be able to get people in the same room to find common ground. But unfortunately, that's not the reality of a lot of people that I encounter, right? I encounter a very different dynamic where they're coming in with their baggage, and they're coming in with their, a spouse who's perhaps abusive, or just doesn't lend to mediation, or is narcissistic, or is alienating. And you can wag your finger and say, don't do that. And we can all logically agree that alienation is wrong, that abuse is wrong, that these things are morally repugnant, but saying and doing are two different things. So if we have somebody who just needs a little bit of litigation before they can come to the table, and sometimes that's what's required. You go through the process, you say, okay, well, this isn't going great. It's not how I expected. And usually both parties have that impression, because I always say when you give a decision to a third party, you're not going to get exactly what you want. And some people want to manifest their own destiny, and they want to be able to come out of it with an agreement that they can live by, and that's good for their kids, that's good for themselves, that doesn't miss any detail or doesn't really misunderstand something. And they'll get a little taste of it and say, okay, this is not where I want to be, and I'd like to be elsewhere. And a lot of times people are unanimous about that after they get a taste of what it's like on the other end.
Right. I use this example sometimes to clients is like, say, do you believe in the COVID vaccine? You don't answer that. But do you believe in the COVID vaccine? Okay, some do, some don't, whatever, that's fine. What about for your 6-year-old child? Do you believe in the COVID vaccine? And very often people would say, no, I don't want it for my 6-year-old child. Well, what if one of you did want it for your 6-year-old child? What do you think the judge would say?
Right.
I don't know what the judge would say, but there's a chance that, this is something that neither one of you want, but there's a chance that maybe the judge would see it different, right? So it's not really the system that you're reliant on to be what's best, right? It's just you need, this is the definition of a civilization, is that you need some agreed upon laws that someone's going to decide, right? And the way I think of there's like the force, right? So we want to be able to force our way sometimes. So what's the most forceful approach would be, let's go to war. What's then in the middle, you have like a civilization where kind of you could force, kind of, and then you have working it out together where you cannot force a voluntary agreement. But if you do have a voluntary agreement, then it's settled because you both voluntarily agreed to it. Whereas, in court, maybe it's settled. And then if you're at war, it's never settled because, especially in a divorce case where someone just does something that they have the advantage. Maybe it's alienation, right? Which I don't like to use that as an example, but whatever it is, right? Whatever they're doing for their advantage, but what happens when the roles reverse? And then you get it all back, like that person's going to be taking advantage back because you're just in this forced dynamic. And it's going to change because there's going to be years, right? Nothing's over after the gavel, hits it's going to continue, and those roles are always going to reverse. So that's like, which one are you going to get? Are you going to get a civil agreement, or are you going to be at war with each other always? Like, do you want to be able to move on? But then you have court, where again, court, does work for some people. What are things that you would say are red lines in court, like that you wouldn't do?
That you wouldn't do in
you
court?
You wouldn't do a motion for that. Like that's, or are there, right? Is there any parameter where you're like, okay, this is like the rules of court or the rules of arbitration system where we would go? Meaning, I guess like you're, negotiating from extremes,
Mm-hmm.
for example. Like, are there any rules or no?
Yeah. So I always like to tell people what their expected outcome is, and then they can make the decision as to where they want to put that outcome, right? Where you want to put it on a shelf somewhere, that's fine. You can put that on a shelf, but understand that we're going to come back to that shelf, and we're probably going to be seeing that outcome at some point. But a lot of times people will ignore that, which is fine. And that's totally their right. They think there should be a different outcome. And I respect that. Reasonable minds can differ. And there are cases that, where I took positions that I thought I would for sure lose and I've won, and vice versa, where I thought this is a slam dunk. It's fine. It happens. And any lawyer will tell you that when you give it over to a third party, those are the types of things that can happen. But in terms of what I will and won't do, so obviously anything unethical is off the table. I draw the line. I don't allow clients to lie in pleadings. If I know they're lying, I will say I will not put that in. You want to certify to it, that's not going to be with my name on the top. If they want to hide documents that exist and not produce them in discovery, I will tell them I will not let you sign that certification that says I produced all the documents. I won't do it. And the way I explain it is, you have a certain book that you live by in maybe your personal life, maybe your religious life, maybe your, professional life. I have this book that I live by, and it's the court rules, and it's the rules of professional conduct. And I will not transgress those rules to every extent, possible. Obviously, mistakes happen in terms of the court rules. It's like a phone book of court rules. So, sometimes it can happen, but not on purpose, ever. So if a client asks me to take a position that's really either not based in the law, based in fact, or something like that, I won't do it.
So you say you have to play by the rules of the game, but you would let your client decide, meaning if you would like to proceed, even though these are what I see as the outcome, as an educated assessment of your situation, I'm fine with proceeding with litigation because that's what the client wants. That's what they're hiring you for.
Right. As long as it's legitimate. As long as it's a legitimate request that's based in law and fact, then the position can be taken. But if it's not, then, I'll tell the client. And I'll always explain the outcomes.
Maybe there's always like ambiguity in the law, right?
Agreed.
So I guess, because when you're saying like, I give you an assessment that this is what's going to happen, but if you want to fight it, I'm fine with fighting it. I'm assuming you're talking about that, not something that's like just
correct.
Doesn't right.
Like here are the likely outcomes, right? Like,
can you give like a few examples of like what's ambiguity? Like, I don't know, like I remember alimony and maintenance in New Jersey. There is like some ambiguity over there, like where no real clear, you have the rule of thumb, but like no clear guideline. Like, what are like some examples where the ambiguity lies?
So when we talk about sort of gray areas, family law is all about gray areas, unfortunately and fortunately. Sometimes there's no gray area, like when you're talking about jurisdiction. And I love jurisdiction because there are no gray areas. It's, did you live here for 6 months? If you did, you can file for custody. If you didn't, file somewhere else. Very unambiguous. And people take comfort in that. I personally take comfort in that. I love jurisdiction because there's a clear answer. But with most everything else we do, It's about the arguments you advance. It's about the evidence you put on. It's about how strong of a showing you can make. But I can't have different facts, right? I can't manufacture facts that don't exist. So I need to work within the confines of what I have. For example, alimony. So we as lawyers love factors because it allows a judge to have discretion, which is a good thing, a very good thing. Judges can make the decision based on the evidence, but you have these series of factors that you have to look to, and you have to say, okay, well, factor number one, what was the lifestyle of the marriage? What is the ability of this party to pay? What's the need of the other party? You have all these factors that kind of, all the ingredients that go into the pot. Now, I can't make different ingredients for you. You're coming to me with the ingredients you have, but I can take those ingredients, I can amplify them. Maybe I can make them taste a little better. Maybe I can display them a little bit better. But you still have a
different vantage point.
Different vantage point, right? Like you get the same 5 ingredients. You get potatoes, cheese, eggs, and 2 other things, and you can make 10 different dishes. So that's sort of what we're doing with the factors. We're coming in with the ingredients, and we're sort of playing around with the factors. Now we have this rule of thumb for alimony, which is 22 to 25% of the difference of the incomes. And it's not the law. It's just something we as lawyers kind of ballpark. And we say, okay, well, let's sniff it out. What would a judge potentially do? And then we tell the client, this is sort of in the ballpark of what you could expect to pay or receive. But there are a lot of other ingredients that we're not accounting for.
And there's things missing, like
right, that's arithmetic.
What's the duration?
The duration, right?
What's the duration? Is there any sort of cap? Like in New York, we have a cap of, it just switched. I think it's 228 right now. Where it just goes up to income to that amount, right? Is this going to go to $1 billion? What about retirement? When is retirement? So there's a lot of other factors other than the rule of thumb that what would happen in those situations. You'll give an assessment, but you can't really know.
Right. And the same is true of custody, meaning a lot of people will default to 50-50 custody at this point. And that's not always in the best interest of the children. So we have actually a lot of experts who will automatically say, because some of the social science, again, suggests that equal custody arrangements are best. But are those parents equally fit to parent? Are they operating with the best interest of the child in mind? Are they co-parenting appropriately? There are a lot of other things that go into the mix versus just a straight 50-50 approach, which I could tell anybody, you don't need to be a judge. You don't need to go anywhere if everything were just a mathematical formula or just, a matter of splitting things equally. You wouldn't need a lawyer or a judge. But because there are all these ambiguities and all of these arguments to be made, and as they should be, because every situation is different. No 2 cases are 100% alike. It's like a snowflake. Everything is just a little bit different and everything is nuanced, and you have to understand that nuance, and you have to approach it in a way that a judge will understand the nuance or an arbitrator will understand the nuance. It's important to frame it a certain way so that you can take the ingredients and make the best dish possible.
Right. And what's a reasonable time frame for someone to expect if they're going through the court system for things to work out, or what should such a thing cost someone? Is there any, when people are looking at these different options, or some people will take the approach where, look, it's just where you ended up. If you were able to mediate, you would have. So it is what it is. Enjoy the ride, but that's
right.
what it is.
Well, a lot will in terms of duration, a lot will depend. And lawyers love that answer. So if you've, and I know you encounter a lot of lawyers, so it does depend. It will depend on what's needed in the case. If you need an evaluation of some sort, either a best interest evaluation or a risk assessment or both, or you need a forensic accountant to get involved to value a business or something of that nature, you're going to be looking at a longer haul than somebody who just has, 2 W-2s and a house and a car, and that's it, and maybe a dog and a cat, and we divide those things up and we move on. And those cases are relatively short and simple, and they have a lot of room for just, the straight arithmetic here. We're going to split the house 50-50. We're going to,
But what would
figure it out.
mean? What would short mean going through court?
Going through court, short would be at least 6 to 9 months, if not longer, because there are certain things that the court wants you to do before they'll have a trial. They'll want you to go to mediation, economic mediation. They'll want you to go to early settlement panel and get an opinion from a lawyer about, and this is just New Jersey, They'll want you to get an opinion about how your case should settle. There are a lot of settlement opportunities during the duration of the case that the court says, okay, we recognize that it's best if the parties figure this out themselves. Plus, the court system is very congested. You obviously want to get things off the docket as fast as possible. But if you're just kind of grinding the wheels and going through the system, it's going to take longer than anybody would ever want, certainly.
Right.
People think, oh, well, it's a relatively simple case. We can get right to trial. Let's do it. But it takes time. It takes time to work your way through these mandatory court events, these case management conferences, and things of that nature. And you're paying the lawyer to do that the whole time.
Right. So we're going to talk about also like the other going to a third party. So we understand like going to a third party, the difficulties in what you're subjecting yourself to is to some outsider to decide. And obviously they need to gather the facts that they could gather, whether it's with evaluations or whatnot. But the other method for, which is kind of like an agreement to do it, but you are going to a third party to decide as well, would be going to arbitrator, or for religious people in let's say Lakewood, or you deal with a lot in Lakewood, right?
Correct. Yes.
They may be going to a Besdin, a rabbinical arbitrator, to arbitrate these cases. How do you compare the two of them? Like, what's the difference?
They're sort of incomparable only because they're really two different creatures. Court is, you are a citizen of this country. You are entitled to go to court. And a public servant then goes and hears your case. That's their job. They hear your case. They do it in their own time. It's not really a fast track option. It's kind of a scenic route option, which is fine. And most of the population falls into that category. If you want to go to arbitration, let's talk about the general population first. For a general population, if you want to go to arbitration, you're basically paying a private arbitrator to hear your case. You're hiring a judge. So a lot of times people will get a retired judge or somebody else, and they'll have certain expertise sometimes in the thing that you're fighting about. So for business valuations, I try to go to this one particular judge because I know that judge understands complex business valuations or medical practice valuations. Those are very complex issues that require a certain level of skill and a certain level of intelligence to be able to understand. So there are certain go-tos. But it's really a fast track option that's reserved for the wealthy, right? You need to have money to pay money to this private judge to hear your dispute on a faster track. But in the Jewish community, things are totally, totally different because you have...
Wait, you would say that, let's say using American Association of Arbitration or JAMS, right? That would be more expensive than going through court?
A lot of times people will say it's less expensive because it's compressed into a shorter amount of time. And you don't have to wait for your lawyer to sit around all day and wait. It can be less expensive. In my experience, it's usually not less expensive, only because of the issues involved. There are very big issues involved that require a lot of big commitments, financially and emotionally and time-wise. And I don't necessarily find it to be a cheaper option for the average Joe, right? Maybe it's a cheaper option for somebody who has a lot of very complex issues and you're not paying your lawyer to sit around all day. But for the average Joe, it's definitely not.
One of the reasons they say it's cheaper aside for time is also you're using one professional, but that's generally not the case. And let's say, JAMS, you would be using 3 professionals because each one of you would have a lawyer plus an arbitrator.
You have a lawyer plus an arbitrator, and a lot of times you also have experts. So you have forensic accountants coming in, and each of you has a forensic accountant. And you have maybe a custody evaluator coming in. And all these people, it takes time and money to testify.
Right.
So
I think in correct me if I'm wrong, I don't know of many people that are going to arbitrators for divorce other than for religious reasons.
I have quite a few in my practice who do for more complex cases, or a lot notoriously if there are tax issues. They'll go to an arbitrator because
versus mediation.
Correct. They'll go to mediation also. But they'll specifically use alternative dispute resolution to solve their case.
Right, that's what I'm talking specifically to, meaning mediation. Again, my clientele is, a lot of, secular. But in arbitration, and I know a lot of, mediators, but in arbitration, that's where I haven't encountered many that are practicing arbitration specifically for divorce.
There are,
So
and they happen in these complex cases, especially when there are tax issues. For example, if somebody is running a lot of expenses through their business and they're not legitimate business expenses, which happens all the time, it's just a fact of life, a court would need to report that to the IRS. There's a case in New Jersey called Sheridan where the judge has to report tax issues. So in order to avoid that, and in order to avoid tremendous tax liability, they'll opt for a more confidential process, which is mediation or arbitration. But if they can't solve it in mediation, it inevitably then
will go to
arbitration as opposed to going to a court for that particular reason.
Okay, so let's move over. Well, let me just ask you first, do they do like a med arb where it's like a mediation that would turn into arbitration? Which I see a lot in the religious, like the Bezdins that do offer mediation. Some are offering like this semi, not really mediation.
Yeah.
That you would see that in the secular as well, where they're offering that.
Yeah, if you do that, you have to be very careful, though, because there's a case called Minkowitz versus Israeli, which says that effectively you need a specific waiver in order to be able to do that. You need a specific knowing acknowledgement that the mediator could act as the arbitrator and vice versa. You need a defined role also, meaning don't just flip back and forth between mediation and arbitration. You need to say, okay, well, we're going to be engaging in mediation now. And then once you're doing arbitration, all the trappings of a actual proceeding need to be in effect, right? If it's a custody proceeding, et cetera.
Because, when you come to mediation, you're there for your needs and wants. When you're in arbitration, you're there with claims, right? So I don't do this. I don't do med arb. I just do mediation. But I understand the difficulty of, and even Bezdins that are offering mediation and arbitration. It's like, wait, am I saying a claim or am I saying what I want, right? Where everybody knows like the first rule in arbitration would not be like, yeah, I would be fine with giving this, and this, because you just gave up something. There's no, it's not like mediation where you could say, hey, I'm open to this. What are you open to? Right.
Right.
So it makes sense, this law. I would just say, obviously, none of this is legal advice here, right?
Oh, yes.
Yeah.
None of it's legal advice, but I mean, it is sort of a cautionary tale, right? If you have an arbitrator who's sort of flitting back and forth between arbitration and mediation, and you don't have a specific waiver, your arbitration is not going to be valid at the end of the day. Meaning,
I would also question they're probably not too good in their craft either if they're doing that. But
you'd be surprised, because people who actually are very effective just might not have the legal requirements, the legal knowledge to be able to have people execute that kind of waiver. And it's a live and learn type of situation. Happens once.
Once I'm fine with.
Exactly. And then you learn.
Fine with. Okay. Right. So let's move over to the more religious, the Bezdin style. What goes on over there? What happens?
Right. So whereas in the general population, it's sort of a rarity to have an arbitration. It happens and it exists, reserved for those types of special cases that need it. In the Jewish community, there are alternative court systems that are effectively set up for people who want to resolve their disputes in a religious forum. And I think they exist in other religions, but most notably, obviously, in the Jewish religion, where in places like Muncie and Lakewood, there are going to be rabbinical courts that are set up for people who want to resolve their disputes in that forum. It's an interesting forum. It's a series of 3 rabbis, and I don't know how much your audience knows about Beis Din in general, but it's 3 rabbis who hear the dispute, and it's a proceeding. It's a formal proceeding that you present your case. It's a little bit less formal than it would be in court, meaning some rabbinical courts will have cross-examination, some won't. Some insist on asking like an expert a question, like the judges, the dayanim will ask the experts questions or the witnesses questions, whereas in others, the lawyers will do that. So a lot depends on the specific rabbinical court. But it's basically run the same way as a court, meaning if you need an evaluation, you get an evaluation. You're not waiving any rights to anything. The only thing that's somewhat different is with alimony. But
so the meaning, what are they ruling based on? It's going to be civil law or religious law? Like, what are they going for? To get religious law or for expedited process?
So a little bit of both. Arbitration is unique in that it's a creature of contract. So you could really agree to anything. Now, some rabbinical courts will allow you to do that and some will not. For instance, I know of some in California that you have to agree to their form arbitration agreement. But in New Jersey, where I practice, things are different there. And you can agree either to decide under Jewish law or New Jersey law. And if it's New Jersey law, the arbitrators just need to sort of get up to speed on that. And it's the lawyer's job to really educate them on what New Jersey law would provide. Obviously, there's a religious tint to it, right? Because whereas secular courts must stay away from religious entanglement, it's under the First Amendment of the Constitution. They can't opine on religion, meaning if you have a difference of opinion, let's say of kosher certification or something like that, you wouldn't go to a court and say, well, this person holds by tablet K or triangle K and this person doesn't, and judge, you make the decision. Like, what can these children eat, let's say, when they're with dad versus mom? The judge will say, I'm not going to decide which certification is better, worse, or indifferent. Like, that's not my purview. But a rabbinical court might say, you know what? You've entrusted us with your Jewish law questions, and we're going to resolve that in a manner that comports with our interpretation of Jewish law. And these people are rabbis.
And that they would be allowed to do under the law.
They would be allowed to do that under the law. Correct. They can entangle themselves in religion, and they do, as much as, to the extent that it's necessary for the case.
Right.
It's a big consideration.
What happens in, let's say, when people don't go to a religious forum and they are, maybe one of them is not even religious, right? And they're going to be litigating over whether they do or don't have to eat kosher. It would turn into, like you're saying, like the court can't really
what is
address
kosher?
it. So then it turns into like a pretextual litigation of best interest of the child, where people are saying this is in the best interest. The child grew up this way or that way, or we were in Rome and there was nothing to eat and they didn't feed the child food. Well, there was nothing kosher, or which way they're doing it. But it's really not whereas what you're saying is that the Beis Din would be able to address these religious questions.
Correct. Even when you're talking about schooling, right? Somebody says, well, you can't put the child in a school that's, let's say, anti-Zionist or anti-Israel in any way, or anti-Zionist, or, and then a court is called upon to interpret that. Court won't do that. Court won't say, well, what are the religious beliefs or the connection to Israel or whatever it is. And I've had that
Unless
issue.
It's like an alienation question.
Unless it's an alienation question, but that's still a real gray area when you're talking about religion. Because once you get into any sort of religious entanglement, the court's going to throw their hands up and say, I can't decide that. I can't decide if this school adheres to this sect versus that sect, or really believes in X, Y, or Z with regard to religion. They're just not going to do it. So you're not going to get the outcome you want because the court's not going to be even able to touch that issue. And to boot, sometimes the court will do something that neither party wants, like put the child in public school, right? And say, well, you two can't agree. The child needs to be in school. If you can't agree, the child's going to public school. And that's something.
And would the going to a religious forum, is it going to be more in favor of like, how are they going to decide which forum they'll go to? Would it be more in favor of the person that's more similar to the arbitrators? How would that be decided?
Not necessarily, because at the end of the day, the rabbinical courts in New Jersey have to make a best interest determination. They have to have a view toward the best interest of the children. Now, do they have to do all the factors that we have under New Jersey law? Not necessarily, but they're required to state what the best interests of the children are. So if they grew up, let's say, modern Orthodox, and there's a dispute there as to where they should go, one person becomes more religious than the other, the Beis Din, even though maybe they're more aligned with the more religious person, could not be, might say, okay, well, they're still going to go with these modern Orthodox schools because that's in their best interest. That's how they grew up. That's what they're accustomed to. And it depends on the goals of the parties. Do they want their children to go to college? Do they, want a year in Israel?
But when
Things of
there
that
is a
nature.
dispute like that, would the less religious parent feel like, wait, I'm nervous to go to such a venue?
Sometimes they are, to be honest. Sometimes a less religious parent is nervous about it, especially if they've become less religious during the marriage or over the course of the divorce. It can be a very intimidating place. But at the end of the day, these people have dedicated and have stated overtly, we're making best interest determinations. So
it's not a religious proceeding per se, meaning
it has trappings of religion, certainly, meaning there's an understanding of religion, there's an acknowledgement of religion. Religion is a big factor, but it's not the only factor. So there are a lot of things that the rabbinical court would consider that a secular court could not consider.
So then let's say financially, like how would that affect whether you're in a religious proceedings versus a secular proceedings?
In rabbinical court, it works a little bit differently in terms of support. Child support tends to be higher, but alimony is non-existent. So you wouldn't get alimony necessarily. I should say generally, you wouldn't necessarily get alimony unless you agree to make decisions under New Jersey law, in which case they could award alimony. But under Jewish law,
but then their child support will be less.
Child support will be less, correct. But child support tends to be a little bit higher in rabbinical court versus in secular court.
Right. I think that's a New Jersey thing because New Jersey child support is a little less than like in New York.
Much less.
Yeah.
Yes.
Yeah. Like in New York, I don't, I think after, a certain income, it's not anymore cheaper in a religious system, more expensive, I guess. Meaning in a religious system, they're going to have a set number, right? Whereas in the court system, it's going to be based on income.
Correct.
So in New York, we have a higher percentages versus New Jersey, where there's this whole calculation.
There's a calculation, but alimony tends to be higher in New Jersey. So that's...
Right, because you have meaning the 22%. By us, it's if you're paying child support, then the percentages, it's like 20% minus 25. I'm probably mixing it up now, but the percentage is not 25% of a difference, and we have caps. So alimony would be less, right?
That's just the way it shakes out typically, that child support tends to be higher in New York, but alimony is lower, and vice versa in New Jersey, because alimony is included as income to the recipient. So child support becomes even lower when you receive alimony because you have less of a need for the child support because you have that extra supplemental income. Now, it's non-taxable income, but it's still nonetheless income, which increases your bottom line. So the calculations are way different.
Right. How does it play out, let's say, paying for private school? What happens in the court system? What happens in the Besdin system?
Typically, and this is another rule of thumb, and it doesn't necessarily have to be this way, but in the secular court system, the percentages are usually in accordance with your income. So if somebody makes 40% of the income and the other party makes 60% of the overall income, that'll be the split, 60-40. And that's typically just how it works. Again, it's not a hard and fast rule, but it's just, how things work. And in addition to that, child support can be made higher, meaning if you have a high income earner above a certain threshold of net income, child support will have a supplemental amount. In the Jewish community, in cases where I deal with in court, I always argue that because that needs to comport with the best interests of the child and the needs of the child, that supplemental amount should be covered in your tuition payment, right? That's the needs of the child.
What do you mean by that?
If you look at, let's say, people who send to public school or secular individuals, a lot of times the supplemental expenses will be covered in, let's say, a higher payment for activities like soccer or, band or something like that. Or maybe they're really, really wealthy and they have horseback riding and the needs of the child are covered because you're paying for horseback riding or something like that. In the Jewish community, people mostly dedicate their excess income to tuition. That's where it goes. So the argument in secular court when I'm representing somebody who's paying tuition is, I understand child support needs to be made higher because they're a high income earner. Let's say they make $500,000 a year. but they have 4 kids in yeshiva. So a lot of times the supplemental amount of child support will be dedicated toward the increased obligation for tuition, let's say. And that's where you're making up the difference. Whereas in the secular world, you're making up the difference somewhere else. Either you're paying the custodial parent more in base child support, and then a supplemental amount on top of that for activities and things of that nature.
So the supplemental, you mean above from where the calculations goes until?
Correct.
Right. So we would call that, let's say, above the cap in New York, where people would go over the cap. And like you're saying, is for if you're paying for private school or there's other things that you're paying for, you might not go over the cap.
Right. We call it above the guidelines because we have the child support guidelines.
Right. I guess just different terms that we use. Yeah.
And that's above the guidelines. So therefore, it would be called an above the guidelines calculation, at which point we would effectively add a supplemental amount to account for the needs of the children. But the question always becomes, well, what are the needs of the children? And in the Jewish community, the needs of the children are typically tuition. That's the needs of the children.
How do you deal with, like in New Jersey, it goes up to like 18, right?
No, it actually goes up at, no, I mean, they didn't move it. It was always like that. It goes up to emancipation. So emancipation.
What is emancipation?
Exactly. That's a fact-specific inquiry.
Because from what I remember in New Jersey, emancipation was 18, but you're saying that's not.
No, emancipation is most certainly not 18. Emancipation is only 18 to the extent that it's somebody has graduated from high school and is not going to college. That's emancipation at 18. If a child's going to college, then college after they graduate from college and up to the age of 23. So child support persists for a very long time.
It's a little bit longer than in New York, because in New York
Yes.
you have 21, but I guess in New York you would need full-time employment at 18. In New Jersey you would need full-time employment at 18? Or?
Not full-time employment, graduation without matriculation to college.
Okay, so
Would
I guess
be
that's
sort
where
of
the
the defining-
18 number comes in.
Right. That would be the
Okay.
defining characteristic of emancipation. If you're done with school, you've made a statement, you're going to work, or you're outside the sphere of parental influence is the legal term of art for it.
Right. Okay. Let's back up a drop. So you have the Beis Din system, which is some sort of hybrid between legal and the religious halacha, how they're going to decide what happens, right? And you're saying like most of your clients, let's just say from Lakewood, or they're going to the Beis Din system, or they're going to the courts. Like, where do people actually end up?
I would say it's 50-50, really.
And how do you find it? Like, you're representing them. Like, you did. I'm guessing you didn't study very long in yeshiva, or learn. Like, you're a lawyer, right?
Mm-hmm.
How do you find it representing clients in the Beis Din system?
So I know enough to get by pretty well, despite the fact that I wasn't, obviously I wasn't like a yeshiva bacher, but I certainly, I went to Stern College. I had 22 years of Jewish education. I grew up in a frum household. Like I know halacha fairly well enough.
So more of education than I guessed.
Yeah.
Right.
So I definitely know it well enough to form an intelligent opinion. For the most part. But then if I don't, and the case is really halacha heavy, which is rare in a divorce, because you're really not halacha heavy in a divorce, you're more best interest heavy, or more, here's how we need to divide assets, etc. Usually it's bank accounts, things like that. It's usually not very Jewish law heavy. If it is, and I'm seeing it's going that way, you would benefit from a towing, somebody who really has that background knowledge and expertise in Jewish law to be able to form a more educated opinion.
So a Tohen would be like a religious lawyer.
Sort of, right.
And
I mean, not an actual lawyer.
Let's say someone's going through the Beis Din system, and who should they hire, a Tohen or a lawyer? I mean, what's the difference between which one you hire?
My bias is always hire a lawyer. And I'll tell you why. And it's not for the reasons that you might think, because, we're so skilled at making legal arguments and the Beis Din will really listen to us and et cetera, et cetera. That's not the reason. The reason really is this is a legal proceeding, right? And in a legal proceeding, you need certain requirements to be met. When you start out in arbitration, it starts from minute one. It starts from the agreement to arbitrate. And you need certain things in that agreement to arbitrate to make it valid and enforceable. And if you don't have those things, the entire arbitration can be thrown out after the fact. So you need to make sure that all of the requirements are being met. For example, in a custody proceeding, you need to have everything recorded verbatim. Everything that goes on in arbitration needs to be recorded. Somebody who's a towing might not know that, in the same way I might not know Jewish law issues as much as a towing does. So that is incredibly important to have a set of legal eyes on it, and also to even negotiate the agreement to arbitrate, because
And do the rabbis know like what has to happen?
they've become aware of what needs to happen, because that's how they have a valid proceeding. They don't want to have a whole proceeding only to be declared after the fact invalid. They want to have a legitimate proceeding that's done the right way, that has legal teeth to it, that can be enforced in a court, that is not just spinning everybody's wheels and wasting time. And, then somebody goes to court and says, wait a second, we've just spent 2 years in arbitration, but none of it's legally enforceable. And that has happened. That has happened frequently. But there's a live and learn type of process that happens where it's, okay, well, this is what we need to do. And a lot of rabbinical courts are legitimized that way. And they really have all of the trappings of a normal, regular
So
legal
that's what you're
proceeding.
saying, that meaning a lawyer would be there really just to ensure that the process happens the way it's supposed to happen. But at the end of the day, to be able to make a religious argument, maybe you won't have the perfect representation to make the best claim religiously, but it's more important to have all the ducks in order and to
Yeah.
make
I view a towing as more like an expert, right? In the same
like
way,
an expert witness type of
right. In the
thing.
same way, I wouldn't go into a custody proceeding without a custody expert, or a business valuation proceeding without a forensic accountant. I need the towing to be able to tell me if I have a halachic question, to be able to answer that in the most advantageous way possible, so that I can make the appropriate arguments.
Right, but you would use them as like an ancillary
A
profession,
resource.
a resource.
Correct.
Right.
Correct.
Got it. And is that becoming more common? Because I guess it's like, let's say I started to see like towings that not necessarily know the halacha even, like
Interesting.
stepping up, maybe not with a yeshiva background, or someone that it seems like is a little more argumentative, where you would see it as more of like trying to play the lawyer role, I guess.
Which is problematic. And I'll tell you why. We have something called the unauthorized practice of law. And you can't masquerade as a lawyer. You need to be what you are, which is a towing, and which is valuable and very useful in a litigation in rabbinical court. But it's not a lawyer. So certain arbitration agreements, you run into this issue where there's a line in there that says, every party had the opportunity to consult with their lawyer or their rabbinic advisor, a towing, about this agreement. And a lot of times those people didn't have lawyers, and they're waiving very critical rights. They're waiving the right to be heard in court. They're waiving the right to a trial. They're waiving their right to, a transcript necessarily of some of these things if it's not a custody proceeding. They're waiving a lot of rights that they might not understand, and they would need a lawyer, or they're waiving the right to a lawyer without the right advice. So when you have somebody saying, oh, I signed this with the advice of my towing, it's somewhat the unauthorized practice of law. And really, a lawyer should be left to do the legal work, and the towing should be left to do, the halachic heavy lifting.
I guess I'll bring this back to mediation, because my view on mediation, whether you need a lawyer in mediation or not, I always think about it, and this is why I tell my clients, is that there's two different areas that you want a lawyer for. One is if you're settling on something that you're not comfortable with. Now, if you're 1,000,000% comfortable with what you're doing, you don't necessarily need a lawyer, because you're 100% with giving up what you're giving up or dividing it the way you're dividing it. And I'm fine with that. And then the other area is to make sure that everything checks out, right? So you want to make sure that your legal documents are going to go through with the court, or that it says what it says, right? And that is another question, which is, are you comfortable, or do you feel that you should run it by a lawyer to make sure that everything checks out to what it is, right? But if you're fully comfortable with the agreement, like you don't necessarily need to run it by your lawyer. If you're comfortable with 50-50, that's what you're comfortable with. You're comfortable with it being a 2255 or every other week, whatever, that's what you're comfortable with. So do you need to run that by the lawyer? Not necessarily. But then there's just making sure my agreement that I'm filing, is it going to actually do what I want it to do? Which is another question. Do I need to run that by the lawyer? Now, I guess where it's different in a Besdin or in an arbitration hearing is because what you're doing is you're actually giving up rights on the onset and you don't know what it's going to be. So I get, for some people that they're going to the Besdin system is for religious reasons. And if you're doing it for a religious reason and you believe that's where, what it is that you're looking for is, I understand where you may go in without a lawyer because you're leaving it up to God, like you're going in with that mindset. But if you're not going in with that mindset, that's where I hear very much what you're saying is like, well, then just make sure that you're doing something legally that would work out. And it would also have like ramifications at the end. How are you going to file your divorce, right?
I see it a lot. And it's disheartening from a human perspective because you were once married, you have children together. Let's just settle this in the best way possible. I think that's the gold standard. I think that's what people should be doing ideally. But sometimes you also have situations where one party is of that mindset. I'm going to bury the other party. I'm going to destroy them. I know, no legal fee left behind. We're going to do this, all the way. And in those cases, it can be daunting to represent kind of like the underdog in that situation, but also rewarding because you're protecting them from this lion who's trying to eat the gazelle. And you sort of have this mindset that you're the one that's going to be able to get them out of this terrible situation that they're in, this really dark time. So in that respect, it's important. Is it the best way to do it? No, but it's important to have people that can be on your side to be able to do that. Now, it's much better to represent the lion. It's much easier because you're representing the villain. And that's easier. My father was actually a public defender. And he always used to say, and I never understood it until I became a lawyer, that his hardest cases, the ones where he got up and he was nervous and he couldn't sleep at night and he was torn up about it, were when he was representing somebody who was innocent. And he knew they were innocent. And that's what tore him up the most. Representing a guilty person is much easier for the lawyer, at least, because you know what you're dealing with. They don't need protection from anybody. They just kind of, it's scorched earth, and whatever happens, happens. They made their facts. You didn't give them their facts. You're stuck with them, but you didn't create them. They come to you with them, and they come to you with their baggage. And again, it's very evident what you're dealing with. But when you're representing somebody who's the underdog, you take extra care of that person, and you say, okay, and you take extra care of all your clients. But in terms of the personal connection and the personal responsibility, when you're representing that person who is innocent, it's definitely like an extra layer of, okay,
so
I got to do this.
How do you feel when you're representing someone that's guilty? Now, I don't mean guilty. This is family law. It's
right.
not, nobody's guilty. Nobody's innocent per se, right? As a public defender, you do have that, right? And you're not up against another person, right? But when you're up against another person, like, how do you feel about that? Like, there's this family, there's this client where you may feel is not playing by the rules. How do you approach representing that person?
So first of all, I'll start with like a truism that I've discovered over my career. People will gravitate toward lawyers who are like them. So if you have somebody reasonable, they're going to gravitate towards somebody who's a more reasonable legal representative. If they're wild animals, they're going to find that person who will represent them in the way that they want to be represented. And you have to find the lawyer that works for you. It's like going on dates. Like, you just need to interview the lawyers. You need to figure out who you jive with, who you have chemistry with, who will represent you in the way that you want to. But if I have a quote bad actor, let's say, bad egg, who's trying to create chaos, I will give them my best advice. My best advice is, you want to resolve this. You want to minimize conflict. You want to be able to come out of this on the other side for your kids in a way that works for everybody. But as my father said, who was a public defender for all those years, everybody deserves zealous representation. It's our legal system. So even if you don't believe in the cause, you believe in the cause. You are the lawyer, and it's your job. And everybody deserves a defense, and everybody deserves a day in court. And I represent people I don't like just as zealously as people I do like. But thankfully, I would say I like the vast majority of my clients because they gravitate toward a lawyer who's like them, which is, I'm going to tell you the truth always. I'm going to tell you what's reasonable, what's logical, and you make your decision. And, I've found that has worked very well in terms of, presentation to judges, in terms of presentation to arbitrators. They respect you more when they find that you're genuine and that you are advocating for something you believe in. So it's just a matter of getting on board with what you believe in and what works best for the client.
So whoever's listening, if you're genuine and if you're looking for someone, if you see yourself in Eliana and you would like for her to represent you, how would they reach out to you?
So
or go on that first date to figure out
the first date.
Right.
Yes. I am on the internet. If you Google me, Eliana Baer, I'm on the Fox Rothschild website with all my contact information. I also have an Instagram, Eliana T. Baer ESQ, Esquire. But it's the ESQ. And, I'm all over LinkedIn, everywhere. So you can reach out to me.
Thank you so much for coming on. Anything that you would like to still cover? Any final thoughts?
No, thank you for having me. And all I would say is divorce is very legally significant. It's very emotionally significant, very financially significant. And it's just important to find somebody who matches your energy, who really understands your issues. One thing you won't find on my bio is that I'm very good at people, and I'm good at reading people. I'm good at dealing with people. My mother always said I should be a psychologist. And every time she says that, and I say, I am a psychologist. It's what I do. It's half of my hat that I wear. Half of the hat is law, half of the hat is psychology. And, I quickly get situations, I quickly get people, and I enjoy what I do because it's really people oriented. So I thank you for having me.
I like that because so many lawyers are like, well, you're wasting your money by telling me all these stories, telling me how much your ex did this and that for you. But you're saying no, I embrace it. I do take on that psychology role.
Well, it's also informative for me. I like to know where people are coming from. I like to know sort of the psychology behind what they're telling me and how they got to the place that they are. I always tell people, even if you think it's an irrelevant detail, you have to tell me, because you don't know how many times somebody says, oh, I have this text message from 10 years ago. I don't think it's relevant. And I say, what are you talking about? That's the pot of gold at the end of the rainbow. That's going to be exhibit A. You need to give me all of the information and I decide what to do with it. So no detail too small for me.
But should they have a therapist also?
Please. Please and thank you. Yes, have a therapist also. But, a lot of times I'll overlap somewhat with that role as well.
Okay, thank you so much for coming on.
Thank you for having me. It's a pleasure.